Now, the ADA bars, in most circuits, not only intentional discrimination, but it also regulates the sequence of an employer's hiring processes. That's a quote from Leonel versus American Airlines, 2005. Ninth Circuit decision. How many of you are in the Ninth Circuit? I think most of you are. Some of you don't maybe know what circuit you're in.
You're sitting in San Francisco.
That's right. Okay, let's talk about Leonel versus American Airlines, because even if you're not in the Ninth Circuit, you may very well come to expect that this is a decision which is going to be endorsed by other circuits. It's one of those Ninth Circuit decisions. We get some goofy ones in the Ninth Circuit, but this is one of those that actually makes very good sense and conforms to a plain reading of the ADA. First, a little bit of background on Leonel. Leonel versus American Airlines, as the case name implies, involved several plaintiff flight attendants or flight attendant applicants for American Airlines. And if I recall correctly, they had met initially in Dallas, where they had all come together for processing of applications, and people are coming from all over the place for this application process. So they thought, we understand that you have to make a conditional offer of employment before you can do a medical examination. We got that. But, people are coming from everywhere. We don't want to have people have to go home, we process their background, and then make a conditional offer of employment, and then have them come back for a blood draw. That's crazy. So why don't we do that here? Let's collect all of their non-medical information. We'll put that in one envelope, and then we'll give them a medical questionnaire and draw their blood, and we'll segregate that. And we won't process that until we've completed all of their non-medical background investigation. That makes sense, doesn't it?
How do I know?
Pardon?
How do I
Well,
know?
let's assume that you don't know, but let's assume that American Airlines did exactly that. They didn't open the envelope containing the non-medical information until after they made a legitimate, bona fide offer of employment based upon a full analysis of non-medical information. Let's assume that, because that is what occurred. Is there a problem with it?
Yeah.
Yeah, what's the problem?
I don't know exactly what the problem is. But
You just know there is.
The course rules.
Yeah, all right. Yeah, okay. Yeah, I know there's a problem because it wouldn't be called Leonel versus American Airlines. You wouldn't be talking about it. Yeah, okay. All right, good guess. Okay, here's what's wrong with it. First of all, let's go back here. The court said that the Americans with Disabilities Act, as we said a moment ago, isn't just about protecting people from discrimination on the basis of a disability. It is a procedural act that imposes obligations on the part of an employer. Essentially what they're saying to American Airlines is, what part of no don't you get? You don't get to violate the procedures simply because it's convenient for the applicant. Applicants can't waive it, and you can't usurp it. But here's what happened. Leonel filled out his medical information, and when asked whether or not he was HIV positive, he said no, he was not. But his blood draw and later his medical records contradicted that. Not only was he HIV positive, but he knew he was HIV positive. So they withdrew their conditional offer of employment. Why? Because he was HIV positive?
Because he lied.
Because he lied. But it's the fruit of the poisonous tree. The court said, you can't lie to a question that is improperly asked. There is no lie to that. It cancels out. It's only a lie if the question is legally asked. And it can't be legally asked until all non-medical information isn't just gathered, but gathered and analyzed. Because people have a right to shield personal health information until after the non-medical phase. They want to be very clear that a person who is disqualified because of non-medical information or conditional offer of employment, medical information. And you can't know that if they all are gathered and analyzed, or even if they're all gathered at the same time, even if they're analyzed sequentially. It enables applicants to learn if the medical evaluation results in any adverse outcomes. That is to say, the examinee would then know, the applicant would then know, gee, I got rejected at the medical stage because of medical information. And convenience, the court said, is no defense. However, cost may justify an all post-COE process. In other words, if an employer says, you know, look, I got it. I know that separating out all of this non-medical and medical stuff, it needs to be done. And we can't ask any non-medical information at the, medical information at the non-medical phase. But life doesn't work quite that simply. Let me give you an example. In fact, the EEOC uses this as an example in their guidance. Let's say that we're doing a polygraph. We're prohibited from doing them in Oregon, but you do them in most other states. And you're doing a polygraph of a police applicant, and you want to ask medical information and non-medical information. You want to ask about use of prescription medication in a way that's non-compliant with prescribed dosages, whether or not they've used other people's prescribed medication. You want to know whether or not they've misused prescribed medication, as well as illegal use that might constitute a dependence or abuse, that is, an underlying mental condition. Can't ask that at the non-medical stage. You can't ask those questions at the non-medical stage. You can ask about use of illegal drugs that wouldn't constitute abuse or dependence, but you can't ask about use that would reveal use or dependence at the pre-offer stage. So you say, we want a polygraph that is ask about theft and other non-medical issues, and then we want the polygraph to also ask about medical issues. Now, some states, some agencies have the ability to bifurcate those polygraphs. They do a non-medical polygraph, and then later they do a medical polygraph. They do that at San Jose, I believe.
No, Sunnyvale, there's a number of agencies that do that,
okay.
And it's popular to do it pre-offer because it's very convenient for the background.
Exactly. It's a way of screening out those candidates who aren't going to make it through it.
But they should go and do the second part.
And many don't.
Yeah, but many don't.
But if you wanted to do both medical and non-medical polygraphs, and if, let's say, you're bringing in a polygrapher to do that, and you can't afford to do it twice, then you can do all of it, the court says, post-offer. So you can do non-medical and medical post-offer, but you can't do medical and non-medical pre-offer. So you can do a non-bifurcated polygraph, but it has to be done post-offer.